Is it true that courts are at fault because they routinely operate in maritime jurisdiction that has nothing to do with the cases before them, and then they pretend otherwise?
Yes, the courts are at fault because they know that they are operating in maritime jurisdiction and pretending otherwise. They are at fault because they have accepted unilateral contracts as valid maritime contracts. They are also at fault because they do not require proof of any valid maritime jurisdiction, even when called on the carpet for failure to do so.
Well, why have the courts malfunctioned in this way and continued on this course for almost 80 years?
Part of the problem is ignorance. A great many American jurists have grown up under these conditions, and they don't know anything different ever existed. There are so many that don't know that statutory law is maritime law, and if the judges and lawyers don't know, who does? There are also so many that don't know statutory law applies uniquely to statutory entities, which are legal fictions created by statutes. The rest of the reason is pure corruption and graft for profit on the parts of those who do know what's going on. You see, federal judges have issued standing orders to invest all court cases through the Court Registry Investment System, aka CRIS. That is, to deposit all court cases as securities into the Dallas, Texas Federal Reserve Bank. You see, every such court case is assigned a U.S. Treasury public debt number, a docket number in state courts, and a case number in U.S. district courts. This makes every court case a securitized financial transaction. After the public debt number is issued, which converts a court case into a counterfeit obligation, that's under 18 U.S.C. 472, sequence 473 and 474. The court administrator counterfeits the same debt obligation by adding a CUSIP number to the instrument. One counterfeit obligation benefits the Federal Reserve, the other benefits the IMF. CUSIP is an acronym for Committee on Uniform Securities Identification Procedure. CUSIP is a copyrighted and registered trademark of the American Bankers Association, ABA. The court administrators work for the banks, not any court system, unless you want to call it a court bank, where the bank always wins. At this point in the fraud, the court administrator working for the banks has converted every court case into a banking financial security instrument, which puts the court itself in the position of being creditor, and both the plaintiff and the defendant are cast in the role of debtors. You see, judges are acting with a vested interest, with insider knowledge, and they are insiders trading in a complete and utter violation of judicial canons. They cannot act without bias when the quantity and quality of their salaries, benefits, and retirement packages are sitting in the docket every day awaiting their investment.